Good morning, everyone. Welcome to our Trust Administration Workshop. Very happy to have you here today. And we're going to be going through a number of topics. And I'd like to start out by introducing today's speakers. To my left, your right, will be Aaron Connor, Managing Partner at Pierro, Connor & Strauss. Coming on camera shortly will be David Wojcicki, CPA. And David has his own firm here in Albany, New York. And we also have with us Michael Bates from TRUSTCO, who's going to be giving you some comments with regard to TRUSTCO services. And special thanks to TRUSTCO, as they are our sponsors for today's program. And they've been sponsoring our Trust Administration Workshop, which we are very, very grateful for. These are our attorneys. We have 6 attorneys here in Albany and 3 attorneys in New York City. And so we are a firm that does a lot of work in estate planning and elder law. We create a lot of trusts. And as part of that trust practice, we do the trust administration, and Aaron does the trust litigation. In today's program, there's TRUSTCO Bank. Thank you, Michael, again, for your sponsorship. Today's program, we're going to talk in detail about how you administer a trust once it's established. We'll start out talking a little bit about trust planning basics. Why do you do trusts? What are the values of each different type of trust? Then we're going to get into the importance of trust funding, what it means to fund your trust, transfer assets, retitle assets, name the trust as beneficiary of certain types of retirement accounts, perhaps life insurance policies. Then the lifetime administration. How does the trust work while you are alive as the grantor of the trust? The reporting and accounting, and David is going to give us a rundown on the tax ramifications of trusts, the rates, and how you file the trust tax returns. And then finally, we'll talk about the administration of the trust at death and how that changes everything, how all the tax issues change, and how the different types of trusts get administered upon death. Right now, we're going to do a little bit of a survey. So a brief poll, and I'd like you to, if you would, respond to these questions, and it gives us some feedback, and we do value your opinions and we value your comments with regard to the programming that we do. We do quite a bit of it, and we like to know what you're thinking. What types of topics do you want to see? Who is the audience is one of our first questions here. And you can select one, or you could actually select more than one. But what interests you about trust administration? Why are you with us today? And we're very happy that you are. But we do want to know what your interest is, whether you are a trustee, creating a trust, maybe you have a loved one that you want to recommend a trust to. But if you would go through that poll, answer those questions, and whoop, that's fine. We are going to go. What happened there? We're going to have Bruce put us back on track.
Yep, you're going to go to your second poll, please.
There it is. So, if you do have a trust, what is your role in the trust? Are you the creator, what we call the grantor of the trust? Are you the trustee? Are you the beneficiary? And as we're going to see, you may be all 3. So if you are all 3, you can check all 3. If you're not quite sure what your role in the trust is, you can click that button. And this will give us an idea on what types of roles each of you is playing in the trust. And we can actually gear our comments to you based upon that. So if you take just a moment, click on those responses. Time's up, pencils down. Let's move on. Okay, so if we can get back into play mode, here we go. We are going to talk about trust administration, the types of trusts, and with regard to how a trust gets created, it can be as simple as creating a will and putting a trust in the will. Every will that we draft in our firm at Pierro, Connor & Strauss has series of contingent trusts in it. What if your beneficiary is a minor? And you can define what that means. Are they under 25, under 30, under 18? Minors trust. What if your beneficiary happens to have contracted a disability? And if they have a disability, then you're going to create a special needs trust. So testamentary trusts are created through a will, living trusts through a living trust. And we can have revocable living trusts, which we're going to dissect, and irrevocable living trusts. So we're going to focus on one particular type of irrevocable trust. There are many types. We use trusts. It's the most flexible tool. It's like the Swiss Army knife of estate planning. You can fix a lot of problems and create a lot of great opportunities through the use of trusts. Life insurance can be made tax-free for estate tax purposes by holding it in a trust. We may want to protect retirement plan benefits. We're going to talk a little bit about that in the Secure Act, which was just enacted in January. As I mentioned, special needs trusts for those beneficiaries who are on Medicaid or perhaps SSI and Medicaid, and you want to protect and preserve assets and income while qualifying them for government benefits. Dynasty trusts, now we're getting into kind of the big leagues. We do dynasty trusts in other jurisdictions like Delaware, Nevada, and those states have enacted very favorable trust laws. So we have created a number of trusts in both of those particular states. There are others like South Dakota and Alaska, but dynasty trusts last in perpetuity. So you can create a family bank, family wealth transfer that forever is outside of the tax system and outside of the liability system. It protects assets for the beneficiaries, other forms of asset protection trusts, and then something that we're going to talk about in today's program. If we want to leave our next gen a little bit better off, if we want to provide for our children and make sure they're getting what it is that they need and that the assets we leave them are protected, a beneficiary controlled trust. And we'll talk about how that gets administered and taxed. So what is trust administration? Aaron, we do a lot of work in trusts and creating trusts, but why don't you give a little synopsis of what the administrative side of a trust is, not the sales side.
So a trust is simply a contract which creates legal relationships, meaning that you have a grantor, okay, the person who owned the property at the time of the creation of the trust, handing it over to a trustee to manage for beneficiaries. In a revocable trust, the grantor, the trustee, and the beneficiary are all the same person. In other types of trusts, they're not. A trust provides lifetime management of assets. What does that mean? So if you become incapacitated or you have a medical event and you need somebody to take over management of your finances, they're all in one nice holding tank, kind of put a bow on it, makes it very easy for your trustee to step in and take control and do what you want to be done. A big one now is avoiding probate. All right. Privacy can also be a big thing. We see, people have a child that no one knows about, or there are other family issues that they want to remain private. Staying out of probate is the way to do that. But avoiding probate, given the current pandemic, has become even more valuable because locally, courts were shut down for at least 3 months, downstate even longer, and the backlog for probate administrations is going to be enormous. And under the best circumstances, if probate takes a year, I think you're looking at more 2 to 3 years now, especially downstate. So the use of a trust is really apropos for that now.
The other issue, Aaron, that comes up is what's the safest way? What if I have children that, and maybe one of them is a problem,
yes,
and could create a liability? I anticipate that my estate may get challenged. The trust gives you a little bit of added protection with regard to potential challenges.
Absolutely. So in the probate process, everyone who's a potential beneficiary, so if you have children, those would include all of your children, has to be cited, and they get the chance for a day in court, essentially, and they can really tie up the process for a long period of time. With a trust, that becomes much less likely. Can they sue a trust? Yes, but they have to go out and affirmatively sue it. They have to put a bunch of money down with a lawyer, and it's going to be a much more difficult process than the probate process, which they can tie up for a long period of time just to leverage themselves, something from your estate.
And the practice of estate planning has shifted and evolved over time. I've been practicing 36 years. Our partner in New York City, Peter Strauss, has another 20 years on me. And so when we look at what used to be the method of operation, what was the MO of most attorneys, it was to do a will, put the will in your safe, and wait for your clients to die. Because of all of the issues, and because people are living such long lives now, and because the cost of healthcare has become so significant, taxes are burdensome, the use of trusts has really proliferated. New York was one of the last states to adopt trusts actively. We've been doing trusts for 30 plus years. And so when we look at trusts, you create a document, but the end of the story is not yet made. You have to then fund your trust. And when we talk about trust funding, it's looking at the various assets. So when you use an attorney, when you have a law firm like Pierro, Connor, and Strauss, you go through the design of the documents, you give your preferences for who the trustees will be, who the beneficiaries will be, what type of trust you want, what the specific terms will be, and then you have a document signing. At that document signing, your work is half done, because I call it half time. You now have to go on and take all of the assets that you have and put those assets into your trust. So on the day of your document execution, and this is your first form that again is in your control panel or on our website, either place, but right simply from your control panel, document 1 is your planning documents list of the things that you will get on the day that you sign. And you'll get copies of your trust and some other things that we'll talk about called the certification of trust, an assignment of assets. So that checklist is going to run you through all of the things that you will be getting on that day. But then there is a process, and this process can be somewhat arduous depending upon what types of assets you have. But the process then is that all of your wealth, your assets, my home, my business, my bank accounts, my brokerage account, my retirement accounts, my life insurance, my annuities, whatever type of assets you have, now have to be woven into your plan. And when you have a living trust, that means retitling assets into the name of that trust. So we have developed for our clients a trust funding kit.
Yes.
And it has 4 elements to it, the 4 tools that you need in your trust funding kit to go out and then do the work of making the trust operative.
So the trust funding letter is something we give people early on, but also at their document execution. It explains how to transfer accounts into the trust. Generally, we take care of putting real property into the trust for our clients, but it also goes through how to assign beneficiaries of life insurance, also of IRA accounts, which can be tricky, which we'll talk a little bit about, but it's a big part of it. To do that, you're looking at Form 3, that's a certification of trust. Most financial houses and banks will accept simply a certification of trust that gives them all the information they need. Occasionally, you need an entire copy of your trust. That's an attorney certified copy. Since that is fairly specific, we did not include that, but that would be part of the trust funding kit.
And that depends on your financial institution.
Correct.
Some banks just work off the certification. Some banks want to see the signature page, the trustee powers, who the trustees are. So they may ask for specific portions of the trust. Generally, you don't have to give them the full document. It's a fairly substantial document, but that certification and the other documentation then goes to your financial institutions, and that's where the trust funding happens.
Absolutely. The only other instance I can think of where we need to provide certain copies of it or pages of the trust is for tax assessors to show that you're still getting your STAR exemption of the irrevocable trust. But that does happen as well.
So the most current document that we've literally just created and revised for today's presentation is our trust funding worksheet. So we would give out a lot of documents and have the clients go about the business of funding the trust and then ask them to send us a variety of things so that we could prepare the last page of the trust. And if you have a trust and you pull it out, the last page will usually read Schedule A. And on Schedule A is a list of the assets owned by the trust. You have to do some of that, we have to do some of that, but then that comprehensive list gives you guidance as whoever the trustee may be to take those assets and manage them, and that's your starting point. That's going to shift and change over time, but that's your starting point. So the trust funding worksheet we're now utilizing to consolidate all of the data so that we can, in fact, have the trust funding done systematically, cogently, expeditiously, and we now have created a new position here at our firm that we call our trust funding coordinator. And Kaylee Sporko is our paralegal who is our trust funding coordinator. So she is working with our clients on making sure that this trust funding worksheet is complete and that we can then transpose it into Schedule A and that you have a fully and comprehensively funded trust that's going to allow you to operate. With a revocable trust, Aaron, we put pretty much everything in, but with an irrevocable trust, we may pick and choose some assets.
Absolutely, and that's going to depend on age, health, client preference, obviously. But with an irrevocable trust, we're never going to put a tax-deferred retirement account in. So we do occasionally see people who have been told to do such a thing. That is usually a horrible idea, especially in New York State. So.
Because it generates tax. So when you have an IRA or a 401k or 403b or whatever your retirement plan, if it's qualified, if you try to transfer that even into a revocable trust, that's going to be a trigger, and it's going to trigger the taxation on that account. Don't want to do that. What we want to do instead is coordinate the beneficiary designation so that you create your trust and you have your beneficiaries in the trust. Your IRA stays in your name. You continue to take your required minimum distributions as you did before, but upon death, it's going to then fold in and become part of the trust for the beneficiaries. It's a bit tricky to name that trust as a beneficiary, so very often we prepare the beneficiary designation, incorporating the trust provisions into that. So we'll talk a little more about the Medicaid trust, which is one of our asset protection trusts. We're not going to talk a great deal today about estate tax planning in the trust realm. It may come back based upon our current deficits and debt, but for right now, federally, it's $11,580,000. That's the exemption for each individual. A married couple is a $23 million exemption. So very few people have an estate tax issue. So we're not going to focus on that today. I say it may come back because we have an election upcoming, and even if there is no change in administration, the tax cuts that went into effect in 2018 expire in 2025. So our $11.58 million exemption is going to come back to a $5 million exemption automatically. So we're following this very closely, and we'll be advising our clients with regard to estate taxes. But for today, we're going to focus on two particular types of trusts. We mentioned retirement accounts, Aaron. We did a 60-minute webinar back when this first passed, and it passed January 1, went into effect, something called the Secure Act. And what the Secure Act did was changed the rules for retirement accounts, some good. So during your lifetime, you now don't have to claim until age 72. If you're still working past age 70, you can continue to contribute towards a retirement account. But the real stinger in the legislation, the federal government was tired of waiting to get their income tax money on the retirement account. So now for beneficiaries, when you inherit an IRA, instead of having the ability to stretch it out over your life expectancy, you have to take it out over a 10-year period. You can take it annually, you can take it as a lump sum at the end of 10 years. But the Secure Act changed the rules, and it changed the way that we have to plan to integrate those retirement benefits into a trust. Think about it, and Dave Wojcicki is going to talk to you about the trust rates. So remember what those trust rates apply to. They will apply to income going into a trust, which would be every dollar from an IRA. And we need to make sure that we draft those trusts carefully to both protect the assets, but also to minimize the tax on the IRA distributions. So the 10-year rule applies. There are several exceptions. I would recommend, if you want to get more in-depth information, go ahead and take a look at the webinar. We covered all of the exceptions to the 10-year rule and some of the planning techniques that have evolved in light of the Secure Act. Trust funding, we do a piece of this, Aaron. So
Absolutely.
at your document signing, we will have prepared a series of documents for you.
Right. The simplest is a tangible personal property. Now, those can be generic, just saying essentially that everything that doesn't have a title, like furniture or photos or other household items, are now property of my trust. We also do a tangible personal property by memo. Okay, and what that does is say, you know, my grandfather's pocket watch, I give to X, or, you know, my great grandmother's diamond ring, I give to Y, which can be important because personal property does get fought over at times, and you can't just divide it like money. So in a lot of instances, it's better that the person who owns the things now assign who they go to in the future. Real property, we always take care of. Deeds, with New York's property, I have to transfer it into the trust, and we take care of that. We also transfer out of state property. And that's a big part of what we do, because if you have property in more than one state, the trust is a particular utility to you, because if you leave it behind that way, your beneficiaries are going to have to probate in two places. So like many people in New York, maybe you have a property in Florida or somewhere in the South because you don't like the winter. So if that is you, you should really particularly be thinking about a trust. Or if you already have a trust, you want to make sure that both properties are in that trust. The other thing we do is assign business interests to trust. This can be pretty simple, generic assignment. Sometimes we're creating a business interest, an LLC, especially to house, let's say, multiple rental properties. We would then assign the LLC to the trust, and even in an irrevocable trust, the grantor can retain a lot of management powers that way.
So in your forms, again, you can access the forms on your control panel. The trust funding kit we talked about, and those are for that's for the assets that you're going to transfer in, your bank accounts, brokerage accounts, etc. We will have at the document execution your deeds prepared so that you can sign them. We then record them and return them to you. As Aaron said, we do a lot of business planning, business succession planning, and you may want to make sure that your business is incorporated in your trust. We have special business trusts that we put right inside a revocable trust. I happen to have one. And the business elements may be administered and managed by different people. They may be administered separately by different trustees, and they may have different provisions as to how that business is going to be managed. So in your forms, the two documents that relate to tangible personal property, and Aaron and I have some great war stories we'll tell you about sometime if you buy us a drink, but very often families aren't arguing over money. They're arguing over personal possessions. So if you want to make this clear, you take the first document and you assign those personal possessions into your trust, and you take your second document and you determine who is going to receive them, item by item, individual by individual. So those two forms are things that we will make available to you and guide you on, but they're very important to keep your family out of court and make sure that you have a smooth administration of your estate. So this is just a schematic of a revocable living trust. Very simple. You're the grantor, you put assets in. It's a revocable trust. You're typically also the trustee. So you're wearing both hats. You then have beneficiaries. And in most cases, you're also the beneficiary, so you get a third hat. So you're the grantor, trustee, beneficiary. In a revocable trust, you're going to retitle, again, virtually everything. The things that come up as questions, do I have to put my cars in? We recommend it. Especially if you have more than one vehicle. In New York, DMV will generally allow you to retitle one car to a family member. But if you have 2, 3, 4, especially if they're valuable cars, you want to retitle them. Boats, trailers, things that have titles. You have to put the titles into the trust. Those are not things like paintings or furniture where you can simply assign them in. You need a document of title in the trust so the trustee can deal with it at a later date. And then all the other things, the real estate and things, go in, not retirement accounts. That's the one asset that stays out, and that's simple. Aaron, it's a little bit more complicated when we start looking at the assets and formulating a plan for what we call our Medicaid Asset Protection Trust.
Well, here, the grantor, the person establishing the trust is not the trustee, okay? We're doing that for separation purposes to protect the assets in the trust, all right? We're establishing this trust, a Medicaid Asset Protection Trust, just for that purpose, to protect assets generally for purposes of long-term care, all right? To make you Medicaid eligible when the time comes. So here, you're losing some small degree of control, all right? It's easy to put your real property in here. The trust contains what we call a life estate, meaning you have the absolute right to live in the property as long as you're alive. You're still responsible for the maintenance and upkeep. So really nothing changes when you put your real property in here. The only thing is that if you want to sell it, you have to get your trustee to sign off on that. Generally, that's not a big issue. And in our trust, we always give you the ability to change your trustee. So if in fact you want to sell your house and your trustee says no, you simply change that person, all right? Whether you put other assets in here, again, depends on health and stage of life and what you want to do. But if you have an income producing financial account, even if you put the account into the trust, you are still entitled to the income from that. Same with rental property. So funding of an irrevocable trust has to be done with consultation with your attorney, whereas the revocable trust is a little more simple. So again, just about everything can go into an irrevocable trust: home, bank accounts, stocks. Annuities can be a little bit tricky, but generally we can put them in there. Life insurance, this is a big one because sometimes people don't change the beneficiary on the life insurance from the spouse to the trust. And when they pass away, maybe their spouse is in a nursing home or not in great physical condition. And if they want to transfer it to the trust at that point, you're looking at another 5-year look back for that transfer. So life insurance is a big one to think about. And as we said, business and real estate interests. What do we keep out? Again, retirement accounts, okay? Some cash, because in New York, you can keep $15,750 and be Medicaid eligible. Obviously, we don't necessarily take you down to that level. That depends on you. It's your money, what you feel comfortable with putting in the trust.
And when you're doing the trust.
Exactly.
If you're on the doorstep of a nursing home and you need to do a trust for Medicaid asset protection purposes, you can still do it, but remember there's a look back and a penalty, so it's much more complicated. Then you're going to do all of this and have everything done immediately.
Absolutely. And again, you can change your trustee in our trust at any time. The bigger stick, as I tell people though, you can change your beneficiaries. So if someone goes off the rails, or unfortunately, which we see a lot, they've taken money from you or other assets because they feel like they're entitled or they need them, you can cut them out. And even though it's quote irrevocable, it can be revoked because we've drafted it very carefully to maintain certain powers for you. So we don't revoke a lot of irrevocable trusts, but if for some reason you don't get through the 5-year look back and nursing home care is required, or upcoming, you don't get through the 2.5-year look back for home care, that's new. You can see another webinar on that. We may need to revoke the trust. So those are very important powers to hang on to.
So the Medicaid laws and the trust laws and the tax laws all overlay planning to try to protect your assets. And they don't necessarily play well with each other. When we're designing a trust, our clients will read the trust and they'll say, this makes no sense to me. And they're right, because we're drafting to weave in tax provisions, Medicaid provisions, trust provisions. The theme of it is, Aaron, that we want to give you as much control as the law will allow. So there are provisions throughout the trust trying to retain for you the control over the assets so that you don't give up that string that you can pull. You can change trustees, you can change beneficiaries, you can actually substitute assets. So if you have one asset outside the trust and one in and you want to swap them, you can actually swap them. So all of those things go into the design and drafting of the trust, but we want to make sure that when you apply for Medicaid, that you have a trust that is not, number one, countable as part of your assets at that point in time, but also that that trust is avoiding probate and is not part of your recoverable estate. So if you do use Medicaid, they can't claw back at your trust. So those are the themes. 2 things to know in New York. 1, your retirement account. The reason we can leave a $300,000, $400,000, $500,000 IRA outside the trust is
It's exempt for Medicaid purposes, meaning it doesn't count.
So your IRAs are fine. You're going to have required minimum distributions. That's income. We have to deal with that. But the retirement account is protected. The other thing to know is the Medicaid laws are shifting. We have new rules going into effect, as Aaron said, October 1st, with regard to Medicaid home care. We've done 2 webinars on the new Medicaid home care rules. We'll probably do a third because there are still open questions as the date of October 1st comes closer. But for now, those 2 webinars will give you an in-depth look at how Medicaid home care rules will be changing. And as we've told all of our clients, if you want to get grandfathered in, that's a big word in the law, getting your planning done under a current set of rules. If you want to get grandfathered in, you need to do your planning before October 1st. If you already have a plan, you may want to have it reviewed before October 1st to make sure that you are going to be in good shape and ready when those rules do change. We're happy to do that for you, whether it's a first consult or a review. We're happy to do that for you as a free consultation. So that's an offer that we make to each and every one of you. But watch those webinars if you're interested in the Medicaid home care changes, something that I think will stand you in good stead. At this point, we'd like to bring up our next presenter, Dave Wojcicki. Hello, David.
Thanks, Lou. Thanks, Aaron. Appreciate it.
David is a certified public accountant. He has his own firm and has for many years here in the Capital District. He has grown over the years, and I'm not sure how big you are today, Dave, but tell us a little bit about your firm and what you're doing.
We're the firm now about 40 people, specialize in everything from tax and, of course, accounting and audit, a lot of trust work. I've worked with Lou and Aaron for a long time, and hopefully we can make this topic, which is somewhat confusing, a little simpler. That's the goal.
Good luck.
Thank you. So just the concept on, it's actually a complicated topic. Taxes generally are, generally, but related to the trust, the big thing is the terminology is much different. The forms are a little different, but if you can break it down and simplify it, it's really not too complicated. If you think of the trust, it's a separate entity. You start with that. If you're an individual, you obviously have a social security number that is used to all your income tax reporting. The trust requires a federal ID number. There are some trusts that do not require to use a separate ID number. We specifically recommend for all irrevocable trusts, you get a federal ID number, a separate ID number, mainly for ease of reporting, but also, you know, what you're trying to accomplish here, as Lou and Aaron mentioned, was to segregate your assets and make sure you're protecting them. And with a separate ID number, it provides any potential mistakes and just gives you a trail of what you've actually accomplished. So Form SS4, as shown on the slide, is the form used to apply for a federal ID number for the trust. You'll then be filing all income tax reporting and all obligations will be under that ID number as opposed to your social security number. Obviously, you file federally like you do individually. Trust is a separate legal entity, a separate tax-paying entity, then has to decide where does it file in what states. As an individual, you file in your resident state where you live, and then if you have assets outside your state, you potentially have other states to file in. Trust works the same way. However, each state has actually different rules as to how they trust your trust income. With your resident state, with your resident trust, and that can be depending on where the trustee is located, where the settler was located at the time the trust was created, where the beneficiaries are located. New York follows, essentially, New York follows where the residence was of the creator when the trust was established. From a taxation standpoint, the general taxation rules follow kind of individuals. Obviously, you pay tax on income, you get expenses, and what's left, either the trust or the beneficiary will pay tax on. But there are different rules based on the type of trust that's created. And there's 3 main trusts that you deal with. One is the grantor trust, one's a simple trust, and one is a complex trust. So grantor trust is probably the majority of the trusts that you're going to deal with, and that's designed mainly by the way Lou and Aaron set up the trust, and that is where the grantor, the creator of the trust, will be taxed on all the income of the trust, whether it's capital gains or ordinary income. So although you have a separate tax-paying entity, a separate filing entity with a separate ID number, the income will actually end up back on your individual return, just like it was as if you hadn't created the trust to start with. It's a relatively simple tax return to file. It just has to go through a couple of steps. There's no gift tax return generally required in those because there's a power of appointment that's reserved with the way that most of the trusts are set up. Second type of trust that we'll see is a simple trust. And a simple trust is again, it's a design of the trust, and the trust is designed such that all the income is required to be distributed out to the beneficiaries. So if the trust has $20,000 in income and it has $4,000 in expenses, there's $16,000 remaining. The trust will require that $16,000 is distributed out to whoever the beneficiaries are. The trustee has no discretion. They just do a computation of what the net income is, and then they distribute out the income to the beneficiaries. There is an issue that we'll deal with in a few slides or a little bit later relating to some tax planning around capital gains. There's a little note on the slide to watch for capital gains, which can cause problems from a trust standpoint. Finally, the complex trust, and essentially a complex trust is really any trust that's not a grantor trust or a simple trust. It's really one where the trustee has discretion for income distributing out. So for example, the trust can be designed such that income is the income, let's use the same example. Income is 20,000, expenses of 4,000, you have a leftover amount of 16,000. The trustee then can decide how much to distribute out. All of that 16, none of that 16, or some of it. And then based on that decision and what is distributed to the beneficiaries, the tax is partially borne by the trust itself. So the trust, with that separate tax-paying entity, will cut a check for its tax obligation, and then the money that is distributed out to the beneficiaries will pay tax on their individual return, just like they would as if they had received the income directly. As you can see, one of the downsides in the trust and estate world is when you file a separate trust or estate fiduciary income tax returns, the tax brackets are very compressed. You can see at the greatest tax, the greatest tax of 37%, the highest bracket, is at income of only $12,750. So you're paying, anytime you make over that amount of money, you're going to be paying 37%. If you compare that to a married filing joint individual, the top bracket is around $620,000. So if you were going to have the same amount of income in a trust as you had outside in a married filing joint return, it would be roughly an extra $60,000 in tax you'd be paying. This is what creates the opportunity or the planning really to look at what trust income looks like and where should we make sure the trust income ends up. As we mentioned before, from a grantor trust, it doesn't matter. It all ends up on the individual return. From a simple trust, the income ends up on the beneficiary's tax return. Capital gains is a little bit of a trickier concept, but the capital gains will either end up inside the trust or outside in the beneficiaries, as is the income in a complex trust. So you would need to look at each year where you stand from an income tax perspective and decide, do I really want to make distributions out to really save taxes? And it is it's a very important concept just because of the difference in tax rates and the really compressed tax brackets you have in the fiduciary area. Definition of income. So this is a concept a little bit trickier, a little bit different, I should say, in the fiduciary world as to how you define income in principle. So income generally, when you talk about from an individual tax return, if you have you sell stock and you make a gain on the stock, that's considered income in the way you think about it, just as W-2 income is and dividend income. It's all considered income. You would pay tax on your individual tax return. But the concept is a little different in the trust world because you have income beneficiaries and you have remainder beneficiaries. So the income beneficiaries are those beneficiaries that benefit from any distributions currently as income beneficiaries, and the remainder beneficiaries are those beneficiaries that ultimately get what's left in the trust after the income beneficiaries get whatever they're getting, and you can be in both classes, but you're getting what's left after some triggering event happens. Usually it's on a passing of somebody. So income in the fiduciary world is really defined as something that an asset produces. So if you think of, if I hold 100 shares of IBM, IBM is a principal asset. The dividend that it produces is the income. So if I have an income requirement to distribute out income, it will be the dividends that IBM produces. But if I take that IBM stock and I were then to sell it and have a gain from that and then reinvest it in Microsoft, for example, the gain on that would be principal, and the stock that went from the money that went from the IBM value over to the Microsoft value, Microsoft is now that principal asset, and that gain would be taxed to the trust itself, generally to the trust as opposed to the income beneficiaries, because again, it's not defined as income from fiduciary accounting rules. Principal, allocation of principal, again, we have to do an allocation for what principal is and what income is, as we discussed, because the trust provisions themselves will tell the trustee, here's what happens to income and here's what happens to principal. It also guides the taxation of the trust assets we talked about and provides our planning. So the money received in exchange for the trust interest, when you put money into a trust, that's your principal. It is going to produce income that will pay tax on either by, as it produces the income, either by the beneficiaries or by the trust itself. Planning. So we talked about the brackets in the previously. Again, 600. You have a bracket of 600,000 on the joint highest bracket, and on the trust fiduciaries, it's around 12,000. On top of that, there's a net investment income tax, which is a tax on net investment income, which is generally defined as dividends or capital gains. It's 3.8%. It's 3.8% over 250,000, any investment income over 250,000 on the married filing joint side, whereas on the trust side, it's 3.8% over 12,000. So again, tax rates are approaching 50% on income over 12 grand as you do the federal side, the state side, plus the net investment income tax. One of the interesting things that we have on the trust side, which is very advantageous and doesn't happen on the individual side, is we have this what's called the 65-day rule. So if you're a trustee and you have rules to follow, a lot of those rules are you need to distribute income out according to the trust, maybe all income. Well, you don't really know what all that income is until the year is over, because up till December 31st, you can be creating income and expenses. So the IRS allows you to make an election on the 65-day rule, which is if you can define a distribution, if you define what your income is and want to make a distribution related to the prior year in the first 65 days of the following year, you can treat it as if it was made in the prior year. And why that's important, it never happens, is you're getting a hindsight look. So we have basically 65 days to look at the income of the trust, 65 days to look at the income of all the beneficiaries, and essentially decide where we want that income to end up. And if you're okay with distributions being made to the income beneficiaries, which are often children, it's almost always a cheaper way to have tax paid. So your beneficiaries, because again, the small tax brackets in the trust, it usually makes sense to make a distribution, and it's really a math calculation as to what the actual optimum amount of that distribution is to be made in the next 65 days to save tax and have the most beneficial tax paid on both the trust side and the individual side. So it's highly unusual. It doesn't happen on the individual side. Lou?
All right, David, I'm going to stay on that slide for just a minute. If I can get control back. There we are. Our poll says that 64% of our viewers are trustees. And so when you're a trustee, what your duties are have to be kind of outlined for you, and those are all contained in the trust document. But when it comes to accounting and tax rules, it's not always clear how these rules apply. The one theme is most of the trusts that we create during lifetime of the grantor are designed specifically as what used to be known as defective grantor trusts.
Yep.
And the accounting rules for those are very simple. We're going to go through the returns. You are in the second half of the program. But when you have a grantor trust, this is pretty easy, isn't it?
Yeah, it's pretty simple. Yeah, the forms are a little different, but once you know how to do it, it's a relatively simple concept.
But then when you fold over into a complex trust and you have the discretion to either accumulate or distribute income, now you have those compressed brackets.
Right.
And, I've been doing this long enough to know why the brackets got compressed, but it's kind of evidence of the patchwork quilt that we have for tax law, where they change one rule, they don't go back and fix the other rules, and they just keep layering. rule upon rule upon rule. But back in the day, you could do something called a Clifford trust, where you could actually shift income out into a trust, have it taxed at trust rates, which were much more favorable because they were the same as individual rates.
Right.
And then get the money back at the end of 10 years. So you had it taxed at a lower rate for 10 years, then you got the money back. So they put in these grantor trust rules, code section 671 to 679, to trap people so that the income actually flows back to you. And in the old days, that made sense because they wanted it taxed at the individual's rate, which was higher than the trust.
Right.
But now we trigger those rules to bring it back into the individual's rate, which is lower than the trust. And so the design is a piece of that. But when you get into the complex trust, how many people come to you as trustees at the end of the year and say, okay, we have $20,000 of income in the trust. We want to minimize the income tax on that amount?
All of them after the second year. The first year, not, people don't know the rules. So when you end up having a big tax liability, obviously from the first year, you have that discussion. The question is, from the trustee's perspective, it's a no-brainer to actually decide how to distribute the income from a pure tax standpoint. The numbers almost always work that way. The question is whether you want to make the distribution depending on who those income beneficiaries are and how you feel about them receiving the money. But from a tax planning standpoint, it's a no-brainer.
Right. So it's something, if you are a trustee, you need to take cognizance of. If it's a grantor trust, it's simple. You'll see the form in just a minute that you need to file. But if it's a complex trust, you need to get those 1099s. You need to sit down, add them up, and then you need to find out who is in the lowest tax bracket.
Yeah.
So you want to go out, you're going to go out and shop for the lowest bracket among all the beneficiaries of that trust and distribute income to those people. And you have basically until March 5th to do it.
Right. Yeah, there's usually a 20% spread between the two. So whatever the dollar amount you're talking about, you're going to save probably 20% of that amount.
Yep. And that could be substantial. So David, we have the new Secure Act, and I mentioned it earlier. We don't have any experience filing returns with it because it's only for January 1 on, decedents who have died January 1 or beyond. And so we will be getting these new rules and the 10-year payouts. Have you seen anything with regard to how to plan for that?
No, I think it's what you guys were talking about earlier is trying to figure out do you stretch it or do you take some intermittently over those 10 years, but I haven't seen anything.
Yeah, so what a lot of people are doing is drawing beyond their minimum distributions now.
Right.
And either reinvesting or putting it into a life insurance policy or doing a systematic Roth conversion.
Yeah, you're talking
about a taxable IRA into a Roth, pay some tax at what I think are going to be lower rates. And I'm going to throw this one at you. It's a question about the future. So I know we don't have our crystal balls, but most people I talk to believe, based upon the current economic situation, that tax rates are going to go up. Do you agree?
Yeah, I think the pre-death planning, definitely. We've been talking to clients about that. I thought you were talking post-death. Yeah, because you could shift. There's a number of things you may want to take that money out before leaving it, depending, because many retirees are in a lower bracket than their beneficiaries are going to be.
Absolutely, and I think we're going to hit a period where we're going to go back certainly to 39.6, which is going to happen anyway at the end of 5 years. But I think the government is going to be struggling for funds. So I think tax planning now and getting some things done and locked in, the state income tax now, is absolutely the way to go.
Yep.
Okay. Thank you, David.
All right. Thank you.
We'll be bringing David back in just a bit to go through the actual tax returns for trusts. Right now, we want to just share a little information on lifetime administration. And Aaron, the revocable trust is a simple tool.
Absolutely. So really the only change in lifetime administration is when someone becomes incapacitated. All right, because generally speaking, in a revocable trust, the grantor is the trustee and the beneficiary. If for some reason they become incapacitated, the trust has a section about how that's determined. All right, usually by a treating physician. You can make this as complicated as you want if it's a fear that you have. There's also ways that when you become capacitated again, you reinsert yourself as trustee. It can be determined by a court. Generally, we want to stay out of that because it's a lengthy and expensive process. Or it can be determined by a disappearance. So believe it or not, we have had clients in the past want to make sure that they could disappear from everyone they know for a longer period of time than the trust provided for. So if that's in your plans, just make sure that you read that section carefully. So.
And the provisions while you are trustee of your revocable trust are no different than today. You're still the manager. You still have 100% control, 100% access. You can do whatever you want with money inside the trust. If you should be determined incapacitated under any one of those standards, now you have successor trustees who are going to step in. It's still a revocable trust. It's not yet irrevocable, still revocable, but you can't revoke it if you've lost capacity. So for tax purposes, we're still going to treat it the exact same way. The income is still your income. One thing that we take great care on is making sure that if you are incapacitated, that all of the provisions that you will need are inside the trust document. And that's not only to take care of yourself, but a lot of our clients say, well, if I'm incapacitated, I want this trust to pay for my children's college education. I want it to support my spouse. So we have to make sure that we have access to the funds during periods of incapacity so the trustee, successor trustee, can step in and do what's necessary to make sure the beneficiaries are fully provided for and protected. And then we have the irrevocable trust.
Right, so irrevocable is different, all right? Lifetime administration, again, the grantor is not the trustee here, okay? So it's important for the trustee to stay involved to some degree in the grantor's life. So one thing that needs to be determined is what income is going to be paid out to the grantor. As Dave said, you want to avoid high taxation rates, so a lot of times we want to pay the income out. Now, there may be cases where we don't, but we have to think about that. Sale of real property, this happens a lot. Is there capital gains tax? Well, if it's a principal residence for 2 out of the last 5 years, then you have a $250,000 per person exemption. If it's not your principal residence, then capital gains tax are going to apply. So that's something that we need to think about. And whether, if you need principal out of the trust, we can get it out, but we have to do it carefully and not directly. So lifetime administration of an irrevocable trust needs to be done more carefully, and you may need to consult the attorney who set up the trust.
And just to clarify, there are semantic issues when we create trusts because terms sometimes are used for multiple purposes. The word grantor means a number of different things. Here we have grantor as being the creator of the trust. And when you're incapacitated, obviously you're not the trustee of a revocable, but from inception, you're not the trustee of an irrevocable. Does that mean it is not a grantor trust for income tax purposes? And the answer is no. So grantor trusts for income tax, our Medicaid Asset Protection Trust almost always will be a grantor trust so that all of the tax consequences flow back to the original creator of the trust. So not until that person is deceased does this then become a complex trust. And so those are some of the fundamentals of lifetime administration. We're going to move on in the second half to administration at death and also the tax documents, the returns that you need to prepare. But right now, I'd like to hand it over to our special guests. And they say, as they say, and now a word from our sponsor. So I'd like to introduce Michael Bates. Michael, if you could come up. And TRUSTCO has been a very generous sponsor of our trust administration workshops. We want to thank you for that. And at this point, hopefully you have slide control. And I'm going to let you take it away.
Thank you, Lou. I appreciate it. Aaron, thank you very much too. And David, yourself as well. This is an excellent webinar. As you can see, many of you have probably attended this before. I know in person, and probably the last time this was done as a webinar. It's a fantastic job that's being done for you. It's amazing information. I'll tell you, as a business development officer for TRUSTCO, my job is to go from here down to Westchester, and I meet with a lot of attorneys and CPAs, and I gotta tell you, I don't see many, maybe none, do the kind of work that this law firm and with David at his CPA firm does as far as presenting information to you to make this process a little bit more easier, at least mentally. Now you know what to do. Listen to these folks. They are the professionals. Go to them. If you're administrating a trust right now, I'm sure you have questions. Go to them. If you aren't, sit down with them. Go from listening to an action step here and put this behind you. You'll have to do some work, but then put it behind you. There's a lot of information. It'll become more comfortable. You got to get into it. That said, thank you again, Lou, Aaron, and David. You've learned that I'm a business development officer from TRUSTCO. And what we like to do, we like to sponsor this because we trust in these professionals to do the job. Naturally, we worry about our reputation, and naturally putting Lou, Aaron, and David up on a screen or presenting or sponsoring this is something that we have no problem with. So let's get on to some of the slides that I'm going to present to you today. Let's see. Okay. There we go. So what does TRUSTCO do, and what can TRUSTCO do for you? And just be real quick with this. TRUSTCO can act as a liquidator of an estate. We can do estate administration. Bruce, if you could take me back one slide. Thanks. So we can serve as an executor, co-executor, successor, or agent. We work naturally with your attorneys and accountants in performing any kind of administration for you. Remember, this is if you need us to do this job, if you're not doing the job yourself, you have no one to do the job, we can liquidate estate and make this easier for you. We're preparation of the accounting, filing the state tax returns, fiduciary income tax returns, and the decedent's final income tax return. Naturally, it's done with your accountant. Provide additional trust services. Naturally, what we're doing is we're saying we're providing extra business services. We are a trust department, as well as a financial services department, interchanging of words right there. Next screen, we can be a trust administrator. So we can be trustee, co-trustee, successor trustee, or an agent for the trustee. So we are acting as a corporate trustee in this case. So again, if you don't have somebody to handle this for you, or if you want to have a professional corporate trustee to handle this, what we do is put the blinders on and follow your documents very, very carefully. We work in a team over at TRUSTCO, so it's not just one person. You usually have an investment manager, an administrator on each account. We'll uphold the standards of the Prudent Investor Act because we are a fiduciary. That means we have to manage your money. We make sure that everything is done in your interest and not in ours. Your interest has got to be first. Consistent review with clients in conjunction with the trust agreement. That just keeps the beneficiaries on and us on the document. Focus on what has to be done and to get the job done as it's requested. Again, for preparation of the filing of fiduciary income tax returns, we always will consult with your CPA on those matters, or choose one of our own when there is no choice made. Provide personal financial advisory services again. We'll go on to the next screen, investment management. Whether you are alive or it's beyond the grave for you, TRUSTCO manages money just like any other brokerage firm, with Schwab or Morgan Stanley, any of them. We do it as a fiduciary. However, we are licensed under the OCC, the Office of Controller of Currency, versus the Securities and Exchange Commission, always having that fiduciary role above our heads. But when we're managing money, we're managing it in a team approach. I may bring in a client and do all the due diligence and set that client's risk tolerance, so on and so forth. But we always bring in a portfolio officer to help with the choices of the stocks, bonds, mutual funds that go into the portfolios for you, and always an admin person to service as well. The approach of a team of 3 is excellent because it allows me to go out and do the financial planning that I do, but it also means that you are getting 100% attention by your back office staff as well, and you have always the ability to pick up the phone and talk to somebody. So we'll customize investment portfolios, review, and we'll provide you with some statements. Those statements come out on a monthly basis, sometimes quarterly, depends on the size of the account and the need. But naturally, your income, expenses, your capital gains or losses will all be there on those statements. Very easily to read those statements. We're naturally in an investment portfolio. We are incorporating fixed income and equities. TRUSTCO also does bill paying services. So if we're managing money, and let's say it comes a point in time where you're just not able to pay your bills, and this happens more often than you think. But TRUSTCO, if we have that account, TRUSTCO will certainly help you in offering a bill paying services. We'll pick up your statements and pay your bills for you. We charge a small fee for that. Let me know if you need services like that, if you want to talk further about that. There are handouts, by the way. I just want to remind you that you can download, and what you'll get there is you'll get the menu of services that I just spoke about. Also, there'll be a fee schedule. So that we, for instance, on the first $400,000 of money we manage within a trust, it's at 1.235%. There's no additional fees because we're a trustee and we're managing money. It's just that fee. Over 400,000, it becomes 1.35%, but then it goes down above $1 million. So that schedule is right there for you. Please download it. Folks, just want to take a real quick statement about the economy. So far in the market, so far we saw, oh my God, we saw a high in our markets on February 12th. We saw a low on March 23rd. Since then, the markets have come back quite nicely. If you notice that I'm going as of June 19th, that's last Friday. Year to date, the Dow is down a negative 8.22%, the S&P a negative 3.14%, but the NASDAQ is roaring at a positive 11.4%. So those are year to date figures this year. Markets are coming back. There's many comments. There's no reason to go into those comments, but I also set up for you investment performance from TRUSTCO in case you're considering having us manage your money now or in the trust arena. Their investment performance shows good results over the last month, quarter, 1 year, 3 year, 5 year, and 10-year period of time. So you'll see that we're pretty consistent as a fiduciary in managing your money. Please download those documents. And if you have any questions, you can always reach me at 518-669-1569, which is my cell phone. And my next slide, I think has, okay, there you go. So the trust administration fee schedule, as I've told you, is for downloading. Investment performance, I just went over for you. Folks, thank you very much for giving me this time, Lou, Aaron, and David. Thank you.
Michael, thank you. What we find is about 30% of the people out there don't have immediate family members. And we get this question all the time. If I don't have a child who can be my trustee, if I don't have someone to serve and take care of my financial affairs, if I'm unable, how do I solve that puzzle? And one of the answers historically has been choosing a corporate fiduciary, a bank trust company. We can build great flexibility into this. We can build a lot of controls. We have trust protectors. So it isn't that you're handing over full control to a trust company. You're hiring them to perform services. And when we're structuring trusts for administrative purposes, having a professional that can do an accounting if it's necessary, that can pay the bills, that can manage the tax implications of a trust has advantages. So corporate fiduciaries can serve a very vital role in the overall administration of a trust. And David, I'm sure you agree, when you have a corporate fiduciary and you're getting records from them, it's a far cry from when somebody is just getting mail and rifling everything and doesn't really know how to assemble things from a return perspective.
Yes, and TRUSTCO's reports are excellent.
Yeah, that's a very good point. Thank you for that, Lou. Appreciate that.
Sure. So it's a question that does come up in trust administration all the time. How do I get a professional and what does it cost? And as Mike said, all trustees typically charge an investment management fee, and the tag along is the trust administration services. So you're going to get all of that, kind of a twofer, if you will, trust administration plus investment management in that one single fee. So we are now going to move on, and we're going to turn it back over to Dave to talk about the actual tax reporting and accounting. Take it away, David.
Okay, so everybody's favorite topic, preparing tax returns. I'm sure this is what everyone's been waiting for. I'm going to walk you through just the concepts of it. We'll move along relatively quickly because you should just be familiar with how to do it. You can, again, from a grantor trust perspective, if you've always done your own individual return, you likely can do the grantor trust return. The simple return possibility, complex return, I generally wouldn't recommend doing, but it really depends on how complicated and large the trust is. So if you think of the concept of tax, just like an individual, you've got income, you have deductions. They have a different concept in trust taxation, which is a actually reduction in the income for distributions. If you remember, you can pass out some of the income to the beneficiaries. The beneficiaries pay tax. And the way that concept works is the trust calculates its income, it calculates expenses, and then it goes through a calculation of what did you distribute out to the beneficiaries that was income related, and it becomes a deduction, which we'll see on one of the forms, such that the trust isn't paying tax on the same money that the individual pays tax on. It's a way to prevent the double taxation because you have two separate legal entities. And there's a real small personal or trust exemption in the trust return, and the personal exemption is going away on the individual side. Calculating tax liability, income, the way you think of income is just like you would an individual. You've got investment earnings, interest, dividends, anything that creates income on an individual side or business would create income on the trust side. The deductions are also very similar. There's a couple of different deductions. If you think of individually, the Tax Cuts and Jobs Act got rid of the miscellaneous itemized deductions, which is where you took your investment fees, some accounting fees, some legal fees. That was carved out because it was part of those miscellaneous itemized deductions. They're still allowable. Certain of them are on the trust side. So the concept is if there's any deductions that you're incurring because they're related to the income that you produced and they're specific to a trust environment, for example, trustee fees, they'll be deductible on the trust tax return, whereas the similar items of expense would not be deductible on the individual side. So there's a little bit of advantage from that standpoint. So we talk about the actual tax returns. The 1040 is where you file an individual return, the form you used. For a fiduciary return, it's a 1041. The circled box has all the different types of trusts or different types of entities, separate entities that actually file a form 1041. The ones we talked about, you can see the simple trust, the complex trust, and the grantor type trust are all mentioned there. So when you file the return, you check the box for the type of return that you're filing so that the IRS knows the rules that you're using in the 1041 filing requirement. The grantor trust, this is the majority of the trusts that you're probably going to be working with, and they're designed specifically that way by Lou and Aaron, and there's many reasons why they're designed that way that are beneficial. But you can see that the grantor type trust box is checked. It's got the name of the trust, it has the trustee's name, it has the separate, again, employer identification number so that the IRS knows where to look for the income that's been reported from a 1099, which is going to be in the ID number of the trust as opposed to the Social Security number. And you'll see this little blue box that's got under the terms of the trust instrument. This is a grantor trust. Income is taxable to the grantor as set forth under certain IRC Internal Revenue Code sections. And it basically tells the IRS, hey, this is a grantor trust. I don't need to go through all the rigmarole of filling out this form because I'm going to give you this attached letter, this letter here that is going to have all the summary of the income that was part of the grantor trust. And you'll see it shows the grantor Social Security number or the ID of the recipient of the grantor letter, this letter. It tells the IRS this trust and this trust ID number received all the income, but you're going to find the summary of this income and the interest, the income and deductions, you're going to find it on the 1040 of this Social Security number. So that the IRS has a trail of the income. And this is all that's required for a tax return for a grantor trust. It's the front page of the 1041 and then an attachment of the letter that describes where the IRS should look to find this income. This income then goes just like it would if you were preparing a 1040. The dividends go on the dividend schedule and nothing is really any different, which tells me if you've done tax returns yourselves before, you probably can do this grantor trust tax returns. The simple trust 1041, again, it doesn't have the grantor letter because the rules are slightly different. You'll see in this one, it's got interest and dividends of $33,000, has some interest expense deduction it took, and it has some taxes it deducted. So the total deductions were $12,000. The concept that's different here is if you take the $33,500 and the $12,000 that was deductions, you would, in theory, have $21,500 that you would be required to distribute. Again, simple trust requires all income to be distributed. You'd write a check to the beneficiaries for $21,500. You get a deduction for that. It's a deduction for the distribution because, again, because the beneficiaries are going to pay the tax, this is a way to take a deduction so that the trust itself doesn't pay the tax. Therefore, you'll get 12,000 deductions plus the 21,500. A simple trust gets a $300 deduction, and you end up with a net loss and no taxes paid by the simple trust. So the K1, which is the attachment to a simple trust, is the document that goes to the beneficiary, and you'll see the $21,500 coming from the trust and the trust ID number reported to the beneficiary and the beneficiary social security number. They'll then take this document and use it for their 1040. So relatively, the example is pretty simple, so it made the simple trust pretty simple to do. They're not all that simple, but the concept is that you'll get a deduction for whatever the beneficiary is paying tax on. And one quick thing I'll mention, Lou, before I turn it back to you. The complex trust, which was an example, wasn't pictured there. It works the same way as the simple trust from a taxation standpoint. The difference is, again, because it's complex, you may not distribute out that all 21,500, maybe half it's distributed, and therefore the trust itself would pay some tax, and then the beneficiaries would pay some tax. But conceptually, it works the same way.
David, that can't stress enough what that compressed trust bracket means, and the fact that you really need to plan carefully, especially if we're going to be using that as the beneficiary of retirement accounts. We want to have the ability to get the distribution deduction and have funds flow through to the beneficiaries. And again, you have 65 days to do that. Same timing, April 15th for all of these returns, correct?
Correct. Yeah, and even just the example we have is 21,000. I mean, you probably could save between 2,000 and 4,000 on that if it was going to remain in the trust versus distribute out. So it doesn't take a lot because of the compressed brackets to make it worth the exercise of deciding what to distribute.
Yep. We're going to be talking next about estate and trust administration. And when someone passes, there are a lot of decisions to be made and elections to be made from both a tax perspective and an administrative perspective. So we're going to talk about administering an estate, paying bills, distributions to beneficiaries, and then come back again for the tax and accounting issues. But right now we want to start talking about how trusts work when the ultimate occurs. There we go. And our principal, our grantor, has passed. Now what happens to the trust? And what if you don't have a trust? Before we go on, I want to remind you that you can post questions. We are going to have a few minutes at the end to talk about questions and take your questions. And you can do that by going to the chat feature. Just click on chat in your toolbar on the right side of your screen, and you can post a question. We'll be reading them and answering them as we go. So Aaron, dealing with estate administration, we have a lot of rules. And as you mentioned, the court system is a bit overwhelmed.
Absolutely. So if you do have a trust and you have assets outside of it without a beneficiary, or you haven't done a trust, you opted just to use a will, then we have to go to probate. So no one has the right to access those assets between the time you pass away and what are called letters testamentary or letters of administration, depending on whether there's a will or not, are issued. At a minimum, that takes a month. Usually it takes longer than that. An estate has to be open for at least 7 months, but that's the best case scenario. Generally speaking, a year is fairly typical on non-contested, relatively simple estates. So those assets are tied up during that time. There's a period of time when things can't be sold. You could lose a lot of money if your assets aren't well invested, or if they're invested in a way that they can't be changed during that period of time. So there's a lot of reasons to use a trust from an asset perspective, from an ease perspective, and from getting things to your beneficiaries perspective.
So what you don't want to do is have an estate where you have to run to court.
Correct.
Because you have motions filed, you have objections filed, you have questions filed. And every time you want to do something, you've got to go back through the court system and getting scheduled, getting on the calendar, not having it adjourned because things go wrong, and having to do that whole formal process through the court. We did a webinar about 2 weeks ago where we had a gentleman on whose father was one of the leading surrogate judges in New York State, Ray Radigan. And Ray Radigan Sr. was a surrogate down on Long Island. Ray Radigan Jr. is the head of wealth management at TD Bank. And we had Ray on, and he was talking about the experience, and he's still involved in the Bankers Association, of the surrogates. And generally in each county, you have one judge that assumes the surrogate's role. In some counties, they rotate different judges in, but generally it's one judge. And we have a lot more people today. We have more people dying today. We have more litigious estates today. That same judge now has about half the staff that they used to have, and they're trying to do the work that the judges did 50 years ago with a lot less volume and a lot simpler estate proceedings. So the court is not the place that you want to have your family dragged through.
Correct.
Whether it's state and probate court or guardianship court. And a trust will go a long way toward putting your family in a position where they're going to be well taken care of. And, you know, Aaron, I hate to be self-serving, but attorneys have a monopoly on the court. We go to court, no one else can. And we can charge attorneys fees for every minute we spend litigating and administering those estates through the court process. And in fact, when I started my practice 36 years ago, that was the attorney's retirement plan. They just built up a wall or a vault full of wills and waited for clients to die and then administered the estates. And back in those days, they used to charge a percentage of the estate. Up until a few years ago, one county locally, that will go nameless, allowed a 5% fee. So 5% of the value of the estate. If you have $1 million estate, the attorney's getting 50 grand to administer your estate. That's not the case in most courts today. But still, the attorney's fees are much, much higher on a probate and estate administration than they are on a trust administration. So some of the pitfalls that you run into as a litigator?
Absolutely. So complicated assets, generally we're speaking about businesses. If there's no one in charge in a business, it can be a really, really detrimental thing to the value and to the estate. Minors are a problem, as well as incapacitated beneficiaries, because we have to get a lawyer appointed to protect their interests, called a guardian ad litem. For involving another lawyer, you know what that means, more fees. All right. Charities, bequests to charities, leaving money to a charity is a great idea, but it has to be done carefully. If you give charity a percentage of your estate, the Attorney General is charged with making sure that they get that portion of the estate. So it can be a very difficult accounting process if you've used a percentage there. Obviously, disharmony is a big part of it. Creditors and you know, unknown heirs can be a very, very difficult one too. So things to look out for. And unsurprisingly, probate and administration comes with a lot of fees, whether that be a court filing fee, an heir search fee, fees for me or another attorney, bonds for executors or trustees, can be accounting fees if we need to do an accounting, and other expenses. So moral of the story is probate can be much more expensive than a trust. And
you might want to mention, Aaron, there's a certain threshold over which you have to do all the same work, regardless of the value of the estate, and it's $50,000. So there's a big difference between an estate under 50 and over 50.
Correct. That was changed just recently from 30 to 50. But once you get to 50 or above, or if you're really even close to 50, you're going to have to do a regular probate filing. But under 50, there are some things we can do, but it's still not the optimal process and a time-consuming process that can be avoided.
And this is why funding your trust, we take so much time and spend so much energy convincing clients that they have to transfer all their assets in. We had an estate that would have been otherwise a probate-free estate that had a car worth $70,000 and a very valuable car. That was the only asset in probate. But we had to go through the whole will procedure. And there was a child that we had to serve that wouldn't sign a waiver. And that estate ended up in litigation just with the car in it. And it cost almost as much as the car to get through the litigation. So make sure you fund your trust to avoid the probate process. At a minimum, you want to make sure that all the assets outside of your trust fall under $50,000.
Yes, but even better, don't have any probate assets.
So that's the trust versus the will. Distributions to beneficiaries.
So generally in a revocable trust, if it's a married person, the first spouse, there's really not much to do. There may be some basis issues that you want to look at. Testamentary trust comes in a lot because if someone is incapacitated upon the first death, we can exempt everything in a testamentary special needs trust. So that's certainly optional. We do see a lot of credit shelter trusts. It's important to note that if you have a credit shelter trust that you did, let's say between 2000 and I don't know, 2015, 2014, something like that, it's a good time to come in and have it reviewed because you may not need that planning anymore. You may want to change it. Disclaimers is a part of our practice as well, where we say, I'm not going to take that portion that flows to beneficiaries, although again, has to be done carefully.
So when you have married couples planning an estate, the estate tax exemption, and I hate to sound old, but I'm old. When I started my practice, the New York State estate tax exemption was $108,333. Those of you that practiced 35 years ago may remember that number. I have not forgotten it. Anyone over that amount had to do estate tax planning. That got reformed upward. It ended up at $1 million for a very long time. And then, as Aaron said, in 2014, New York State increased its exemption, phased it in, and we are now at a New York State estate tax exemption of $5,850,000. If you're a married couple and your estate's under that, and you have one of those older wills or trusts that has very complicated estate tax formula language in it, you can simplify your estate tremendously. Save a great deal of time, energy, and money by simplifying it and removing some of those complicated tax provisions, because we now have a $5.85 million exemption. So in a revocable trust, Aaron, we can do an individual trust or a joint trust. So we're doing a lot more joint trusts
Correct.
today. So a married couple, one trust, two spouses, but the administration is very simple.
Right. In a time of estate tax planning, we did a lot of separate trusts, but now in a joint trust, it is very simple, especially on the first death. On the second death, not much more terribly difficult, but it could go outright to children and beneficiaries. More likely, if you've done a trust with us, we've created a beneficiary controlled trust, which is a trust whereby your beneficiary gets their share, they control their share, but it's creditor protected, right? Number one creditor out there is a soon-to-be ex-spouse, but there are also lawsuits. There's long-term care costs for them as well. So the beneficiary control trust is a great way to really have your cake and eat it too, because you have full access to the money, but it's protected from creditors.
And this is a great way to protect your kids. I have become a tremendous believer in this technique. I have it in my own documents. The New York case that really gave rise to this occurred about 15 years ago, and since then the body of law has evolved. But creditor protection is very difficult to get for yourself. If I have an assets that I'm the grantor of, and I want to create a trust and I want to try to shelter my assets, New York State public policy says I cannot do that. I cannot spendthrift or protect my own assets from my creditors through the use of a trust, but I can do that for my children. So when I create my estate plan, I want to create trusts for my kids, these BCTs or beneficiary control trusts. My children are their own trustees. They're their own beneficiaries. They control their own destiny. But if they get divorced, if they get sued, have a judgment, have a bankruptcy, the assets that are left to them are fully protected and will get down to the grandchildren and stay in the bloodline. So another name for this trust is a bloodline trust. But when we lay out the value proposition for these trusts to parents, it almost always is recognized that this is the best way to leave the inheritance. And if you're going to do this, it's all the more reason to have a living trust yourself, because it's another way that you can throw your family back into court.
Absolutely. So without this, things can go everywhere that you don't want them to go. If you have set up without trust, you can really end up in a bad place. And we all want to stay out of court. We want to save the time. We want to save the money.
And what happens is, if it's in your will, it could be one of those testamentary trusts created under your will. But when the will goes through probate and the probate ends, the court's role does not end. The court has ongoing lifetime jurisdiction over your child's trust. And that's not where you want to put your child. You want to have them acting independently and free from court interference and oversight. So doing a revocable trust or an irrevocable trust, the Medicaid Asset Protection Trust, if you have a living trust, you create these trusts so that the trust simply doesn't end, it divides, and you create a share for each of your beneficiaries. and the beneficiaries then take that share. They can be their own trustee or not, depending upon what their capabilities are, but their assets are protected. We want to bring Dave back at this point to kind of round out the conversation and talk about the tax filings for a decedent.
So the final for a decedent, there's a 1040 that will be filed for all income and expenses up through date of death. There's a few elections that can be made around that, and that's to bring, generally you're paying tax on income pre-date of death and expenses pre-date of death, but there's some things that you can bring back that are paid post-date of death, medical expenses, and there's an election related to savings bonds that you at least be aware of, especially if the decedent passes away in the early part of the year, because you still get your full exemption, your full standard deduction. So if you can accelerate income into the final decedent's 1040, it often pays benefits than having it go to the beneficiaries. Estate 1041, that's all the, if we don't have a trust, then there's anything that's left over outside of that, we'll have a fiduciary return, just like the trust returns work. It works the same way, income less expenses, anything not distributed out to the beneficiaries is the tax paid by the 1041. And the estate tax return is the tax return for the actual value of the assets held by the decedent at date of death. Again, as Lou mentioned, with the estate tax threshold being so high right now, it's unlikely there would be necessarily a estate tax filing requirement. But if you want to have the portability election made, which is where if I am married and I have my 11 million and my spouse is 11 million, it's 23 million between the two of us. I cannot get that carryover if I don't use the 11 million unless I file a 706 or the estate tax return for the first decedent to pass away. So the decision really is made, do I want to roll the dice and assume that my spouse is not going to have a taxable estate, or do I want to take a guess that they're close, or they may win the lottery and push me over the threshold and there would make me file a protective 706. And I think that's about it. I think everything else is just timing related to it. The final year's decedent return does have some timing issues related to it that you probably should get some advice related to. Otherwise, it's just a 1040.
And for accountings, David, not many estates have to do a formal accounting, but there are circumstances that do apply.
Yeah, some of them, if it's in the trust document requiring a formal accounting, it requires a formal accounting. If there's an issue related to it, if there's a third party related to it, specifically maybe there's a guardian, there's accountings required, but they're very detailed and they can be expensive. If you do not, if there's a litigation, if you have to go back and recreate the accounting, it's a very time-consuming and costly process, and not fun.
A formal accounting requires not just the income that came in, but it requires a reporting on every trade that occurred in the account.
Yeah, it's a detail of every transaction. So you'd have to go back to day one if you didn't do it and show every in, every out. What was it for? What was the purpose of it? Who was it to? You need to avoid it if you didn't have it. If you have a third party trustee, for example, TRUSTCO, they obviously produce the accounting pretty much every year.
Aaron, probably the most common occurrence where we see a formal accounting required is when clients leave a charity as a remainder beneficiary.
Absolutely. So again, it's the Attorney General is charged with making sure the charity gets what they're supposed to get. So the only way you get to that end is by doing a formal accounting. Other times, formal accountings are required in litigated estates where there's questions about where the assets are or where they should be. So
there are ways to leave money to charity. We think it's a wonderful thing, and charitable giving is a big part of the practice that we have. We do a lot of charitable trust work and private foundation work. But when you're structuring it, one of the assets that you can leave to the charity that is a very tax efficient asset is a retirement account. So you can avoid the 10-year rule, the new Secure Act rules altogether by naming the charity as beneficiary of the IRA. Leave your other assets to the individual beneficiaries because they may get a step up in basis at death and wash all the capital gains tax out. So very often we simply swap distributions. We have wills that leave highly appreciated stock to charities and individual retirement accounts to individuals. Just by flipping those over, David, we're saving 30 or 40% on the value of that IRA.
Correct. That's a good idea.
And you don't have any accounting requirement. The other way is if you leave the charity on for, say, 25% of my residue, the remainder of my estate, you have an accounting. because you have to determine what that residue is. If instead you say, you have $1 million, I leave the charity $250,000 and the balance, the residue, to my heirs, you don't have an accounting requirement. So you can name it as a specific bequest and avoid that accounting. So in the drafting and how you structure your philanthropy and your charitable giving, that can be done in a much more efficient way, because we have formal accountings now going back 20 years where you have to recreate those transactions, and it is a disaster.
Yeah, and it delays the finalizing the estate immensely.
So one question that comes up is, how do I keep this organized? How do I make sure that my plan is being looked after year over year? How do I make sure that my team, my attorney, my accountant, my financial advisor, how do I make sure that they're all on the same page? And for that, we have an annual maintenance program we call our Professional Advocates Lifetime Maintenance System. We have an online data and document storage program that we use and set up in a fully encrypted website for our clients. We have an annual meeting where we invite their accountant, their financial advisor, their family. Very often this becomes a family meeting. And we review the entire estate plan to make sure that the returns are being filed properly, the trusts are being administered properly, and to make sure that the trusts are fully funded. It's an excellent insurance policy to make sure that your plan works, and that there's an agreement in Form 12 in the document list. If you want to see what is specifically included in our PALMS program, take out Form 12, take a look at it. That is actually the formal contract that we enter into with our clients to maintain their plan year over year. So with that, we'd like you to stick around for a minute to take a brief poll, and we are going to get to your questions. So if you've posted questions, stay with us. We are going to take them. We're going to run a few minutes over, but let's get to our next poll question. I'm interested in scheduling a free consultation regarding, and here's where you can say that I want to talk to David Wojcicki, Aaron or myself, or Mike at TRUSTCO, Michael Bates, or if you're not interested, let us know that as well. So that's poll question number 1. We'd love to sit down and talk to you. And again, you've been our guest for this 90 minutes. You'll be our guest for another consultation. And that'll go without charge. At the end of that, we will have a conversation about the services and fees based upon what your particular plan is. All right, so let's go to poll question number 2. If you prefer to meet, now we have all kinds of options. We can do video meetings just like this. We can do telephone consultations, or we can do in-person meetings. So let us know what your preference is in terms of how you would like to meet GeoChem in Fort Lee. So we are able to service New Jersey clients.
Yeah, the other states aren't a problem.
All right. So with that, I want to thank you all for joining us today for our Trust Administration Workshop. The next Trust Administration Workshop, we're hoping to be back live and in person on October 1st, and that would be at the Capital Region Chamber of Commerce. If not, we'll be back on the video, but we welcome you to join us. If you thought today's program was valuable and worthwhile, tell your friends. We would welcome them to the October 1st version, and again, hopefully we will be there live and in person. I want to thank you for being with us and staying with us throughout the program. David Wojcicki, thank you for sharing your expertise and your time with us and with our audience. Again, thanks to TRUSTCO Bank for sponsoring today's presentation. And as always, from Pierro, Connor, and Strauss, thank you. And we would love to see you here at the office or up there on the screen. And we do offer a free consultation if you want. Thank you, and we'll see you next.